Welcome to the Deep Dive. Today we're tackling two really critical legal questions. They're shaping our digital age, how businesses operate online, and it all comes from one specific trademark case.
That's right. We're diving into a Supreme Court petition, Stanislav Arbit versus Schneider Electric SE. And our mission here is to unpack, how companies function online, what kind of proof you need in court, and really what these big disagreements between courts, these circuit splits, mean for you.
Okay, let's jump right in. First big topic, digital age jurisdiction. This sounds, complicated. If a company, say Schneider Electric, has a website anyone can see, does that automatically mean it's expressly aiming at someone in, let's pick Arizona, for a legal case about an intentional wrong, like trademark infringement?
Exactly. And personal jurisdiction, the court's power over a defendant, is key. For intentional torts, you often need this express aiming. The defendant had to target the state, right? Now, the Ninth Circuit, they have an interesting take. Look at the Briskin v. Shopify case.
Oh, yeah, Briskin. What do they say?
Well, they ruled that even things like automated torts, harm from automated systems like website cookies, tracking data, that can count if it leads to data being intentionally sent to a device in that state.
Huh. So, the website knows it's sending data to Arizona.
Kind of. They also said you don't always need differential targeting, like specifically favoring one state market over others, especially if a company like Schneider Electric just serves the whole country online.
Okay, let me try the analogy from our notes. The Greasy Macron's Pizzeria one. So the pizza place knows my address when I order, right? Is a website like www.se.com doing something similar? It knows my IP address, which points to, say, Phoenix.
Yeah.
So even just sending website content, is that purposefully directed?
That's a great analogy, actually. And for Schneider Electric, it seems to go further. Their site, www.epsi.com, apparently has Arizona-specific stuff, lists, 30 resellers in Phoenix? They even recruit people there.
Wow. Okay, so not just a passive website then.
Right. Those online and physical connections, plus that Briskin ruling from the Ninth Circuit. It builds a pretty strong case for what's called purposeful availment in Arizona. Basically, they intentionally engaged with the state, so maybe it's fair to sue them there.
And this is where it gets really significant. If the Ninth Circuit sees websites this way as express targeting, that could clash with, pretty much every other circuit court.
That's the potential split, yeah.
Why does this matter to, our listeners? Well, it totally redefines the risk for companies online. Suddenly having a website accessible everywhere with some local links could mean you can be sued there. That affects everyone.
Big implications. Okay, so let's say Arbit can show jurisdiction. What's the next fight? It's about the level of proof needed just in pretrial hearings. Is it just a basic showing, a prima facie case? Or do you need more, preponderance of the evidence? More likely than not.
Right, that seems like a huge difference. What's usual?
Usually it's prima facie if it's just based on papers, written evidence. But if the court holds a hearing to sort out factual disagreements, like it did in Arbit's case, then it often bumps up to preponderance.
Okay.
Although, interestingly, the First Circuit has this middle ground, a likelihood standard, sort of in between.
And why is this standard so critical?
Well, think about it. It directly impacts how easy or how hard it is for someone bringing a lawsuit, especially someone representing themselves, to even get their case properly heard. It changes the cost, the effort, everything. It's about access to justice, really.
Makes sense. Now, there was another layer, too, wasn't there, about Schneider Electric's structure. SE, the parent company, said, hey, we're just a French holding company, only 2 employees, totally separate from our U.S. subsidiary.
Yeah, that was their defense. But Arbit pushed back using the alter ego or agency idea.
Piercing the corporate veil.
Exactly. Sometimes a parent and subsidiary are so tangled up, the law says, nope, for this purpose, you're basically one company. It looks past the formal separation.
And Arbit had evidence.
Seems so. SE's own slogan, we're the most local of global companies. That sounds pretty integrated, doesn't it? Plus things like shared addresses, shared managers. This Amer Paul guy was apparently an exec for SE and president of the Arizona part.
Oh, interesting.
And using the same website domain, www.se.com, for U.S. employees. Contracts signed by the subsidiary that covered all affiliates. It paints a picture of, maybe not so separate after all.
So the takeaway for you listening is how these big global companies set themselves up, but also how courts might dig deeper, especially if someone's claiming intentional harm, to make sure the right entity is held accountable.
Right. The formal structure isn't always the end of the story.
So wrapping up, We've seen how just visiting a website could potentially land a company in court far from home. And we've looked at how much proof you need just to get that case started and how that varies. These aren't just, dusty legal points.
Not at all. They dictate where and how you or any business might have to answer for actions in this super connected world.
It leaves you wondering, doesn't it? In an era where a company can be, like SE says, the most local of global companies, just through its digital front door, what does home even mean for a company in the eyes of law anymore?
And maybe more importantly, how does justice need to adapt to keep up with that reality? Something to think about.